Hi, I'm attorney Andrew Thompson. I want to talk with you in this video about an experience that I had recently with a homeowner in fighting a foreclosure in court. They've had a very long and difficult legal battle. It actually began back in 2006. After their mortgage documents were signed and they started paying on their mortgage faithfully for several years, the note was endorsed and turned over to a different servicer, then to a different bank, and so on and so forth. Eventually, the homeowner got in a position where they couldn't pay for their mortgage. They tried to work out a modification with their lender, but the lender wouldn't really cooperate. They went through this process for several months, and eventually the bank filed for foreclosure. The case has been in foreclosure now for over 3 years. During the course of that time, another attorney actually filed a counterclaim against the bank. Eventually, in litigation, in most states, wherever you have a judicial foreclosure at least, like we do here in Indiana, the bank, the creditor on the promissory note, will file for summary judgment. What's called summary judgment is an opportunity for the court to make a decision on the case without actually having a trial. This, of course, is a big disadvantage to the homeowner, to the debtor, because they don't get a chance to present evidence as to why they may have been late making payments and any other defenses that they have to the case. Well, here's how the experience that we had in court went, more or less. The bank had filed a complaint with a promissory note attached to the complaint. When they filed for summary judgment, they actually attached a different copy of the note. We questioned that note because the endorsements on it from one party to another were different. The court wanted to hear about this. The court also wanted to hear about the diligent efforts my client had made to try to modify the loan with the bank and also to make payments on the loan throughout its history in default. But of course, if you've been in their position, you know that once you go into default, it's very unlikely or almost impossible to get the bank to accept late payments. As you work through the process of a loan modification, that can be a very tedious, arduous, and almost impossible process in itself. So we get to this point, the bank wants to hear our story. They want to hear why the homeowner is in the position they are. Why are they in a position where the bank is claiming that they haven't made a payment on the note in almost 5 years? Actually, they've been trying to do so almost the entire time. What we could point out to the court is that the bank's accounting for what was due on the note wasn't accurate, that there were problems with it. They couldn't determine what actually was the amount owed on the note, and there were several other problems as well. The key to all of this is, as I told the court, is that the homeowner's in a position where they may not or possibly cannot know actually who they should pay for what they owe. The bottom line on all of this is that if you're in a situation where you've been forced into default on a mortgage, you may have hope, you may have defenses, and they can be pursued in court. Don't give up just because a bank is pursuing foreclosure against you. Talk to competent counsel today about your rights and see how you can proceed. My name's Andrew Thompson. I'm with the Thompson Law Office in Carmel, Indiana. You can reach us by phone at 317-564-4976 or find us on the web at www.thompsonlaw-in.com.